Right. Good morning, everyone. I think we will start now because it's 9:02. I'm Chelsea Carter, and today I'm going to be talking with my colleague Douglas Cochran about limitation after the case of Canada Square and Potter. Now, as you can see on the slide, I've reproduced Section 32 of the Limitation Act 1980, which of course deals with the postponement of limitation in cases of fraud, concealment or mistake. Now, we can see in subsection 1, it deals with cases where the action is based upon the fraud of the defendant, cases where any fact relevant to the plaintiff's right of action has been deliberately concealed from him by the defendant, and cases where the action is for relief from the consequences of a mistake. We can then see, of course, in subsection 2, that also deals with deliberate commission of a breach of duty. Now, it's those two parts of Section 32 that Canada Square and Potter dealt with, and it's those parts that we're going to be looking at today. Now, I think it's important from the start, many of you may be familiar with the facts, but I think we should just nip through them. In Canada Square and Potter, it all started back in 2006 when Mrs. Potter entered into an agreement with Canada Square. Now, the agreement was a credit agreement within the meaning of the CCA. Mrs. Potter borrowed just under £21,000 from Canada Square, comprising partly of a loan, but also of payments for a payment protection premium. And that was just under £4,000. Now, the premium related to Mrs. Potter's purchase of the payment protection insurance policy, which Canada Square arranged on her behalf. Now, it was over 95% of the premium that was paid to Canada Square as commission on the sale of the PPI policy. And of course, as we all know, following the Supreme Court case at Plevin, that is exceptionally high and has tipped over the balance of what is acceptable as an amount of a commission. Now, Canada Square didn't tell Mrs. Potter about the commission. The agreement then ended 4 years later in 2010. Now, it was only 8 years after that Mrs. Potter issued a claim against Canada Square seeking to recover the amounts that she had paid under the PPI policy, of course, plus any interest over the period that the policy had run for. And Mrs. Potter claimed that Canada Square's failure to disclose the substantial commission rendered the relationship between the parties unfair within the meaning of Section 140A of the Consumer Credit Act. Now, Canada Square argued that it was too late for Mrs. Potter to bring her claim because Section 9 of the Limitation Act imposed a 6-year limitation period, which had expired many years previous. So this is where Mrs. Potter turned to Section 32 of the Limitation Act and contended that her claim was not actually time-barred because the limitation period did not start to run until she actually found out about the existence of the commission after taking legal advice in 2018. She ran the argument that until that point in time, the commission had been deliberately concealed within the meaning of Section 32, and therefore she hadn't known about it. Now, this started in the county court. It went through to the High Court, the Court of Appeal. All of those courts found in favour of Mrs. Potter, and we then had this appeal to the Supreme Court. Now, in the Supreme Court, they were asked to clarify the meaning of the phrases deliberately concealed in Section 32(1)(b) and the phrase deliberate commission of a breach of duty in Section 32(2), so as to determine whether Mrs. Potter's claim against Canada Square was issued too late and was therefore time-barred. So very straightforward. Now, I'm going to be dealing with the first part of that, the deliberate concealment in Section 32(1)(b), and my colleague Doug is going to be dealing with the second part, deliberate commission of a breach of duty in Section 32(2). So, issue 1. Did Canada Square deliberately conceal the commission within the meaning of Section 32(1)(b)? Now, the court looked firstly at the meaning of the word concealed. They separated concealment and deliberately. So we're looking at concealed. Now, a fact will have been concealed if the defendant has kept it secret from the claimant, either by taking active steps to hide it or by failing to disclose it. Now, Section 32(1)(b) doesn't draw a binary distinction between cases involving active concealment and cases of non-disclosure. So the defendant can't use the excuse that they simply didn't tell the claimant about the commission because the claimant never asked. Now, the claimant does not need to establish that the defendant was under a legal, moral or social duty to disclose the fact, and nor do they need to show that the defendant knew the fact was relevant to the claimant's right of action. Now, in the Court of Appeal, before this was appealed up to the Supreme Court, Lord Justice Rose expressly stated that inherent in the concept of concealing something is the existence of an obligation to disclose it. Now, this followed the previous case law, in particular the case of Williams and Fanshawe, which is a Court of Appeal case from 2004, and the case of the Critty Palm, which is a Court of Appeal case from 2006. Now, those decisions were to the effect that the claimant must establish that the defendant was under a legal, moral or social duty to disclose the fact, or that the defendant knew that the fact was relevant to the claimant's right of action. But the Supreme Court disagreed with that. The Supreme Court held that the word concealed means to keep something secret, and that's it, either by taking active steps to hide it or by simply failing to disclose it. Now, a person who hides something can properly be described as concealing it, whether there is an obligation to disclose it or not. Now, the Supreme Court gave an example. It's a rather strange example, but it is that an elderly lady who was afraid of burglars might conceal her pearls before going to bed, without any implication that she was obliged to leave them lying in plain sight. Now, it's rather strange, but we can all see the point that's being made. Now, in this case, Section 140A of the Consumer Credit Act imposed no duty upon Canada Square when they were selling the PPI policy to Mrs. Potter. And actually, the unfair relationship jurisdiction in the Consumer Credit Act didn't even exist when Canada Square sold the policy to Mrs. Potter in 2006. It only even came into force in 2008. But that didn't matter. The court said that Canada Square couldn't use the excuse that they weren't legally obligated to tell Mrs. Potter about the commission at the time of selling the policy, because concealment was made out as a result of their simple failure to disclose it. Now, all that is required is that the defendant deliberately ensures that the claimant does not know about the fact in question, and so cannot bring proceedings within the ordinary time limit. So ultimately, the Supreme Court gave the word conceal its ordinary English meaning, namely to withhold that information from another, whether that be actively or passively. And on that issue, there's no question of wrongdoing or any breach of duty involved at all, whether we're looking at a legal duty or otherwise moral, social, etc. Now, the court then moved on to the meaning of deliberately. Now, the defendant's concealment of a relevant fact will be deliberate if the defendant intended to conceal the fact in question. And here, the Supreme Court rejected the Court of Appeal's previous finding that deliberately could also mean recklessly in this context. So the defendant must have considered whether to inform the claimant of the relevant fact and decided not to. So there's got to be some level of consideration, so that the decision was made knowingly and therefore deliberately. Now, I've produced here a quote from paragraph 108 of Canada Square and Potter. It's a good one. And it simply states that if the defendant has concealed a fact from the claimant and has done so deliberately, that is to say knowingly, then he has the means to start the limitation period running by disclosing the fact. If he does not do so, but chooses to keep the claimant in ignorance of the fact which she requires to know in order to plead her claim, then it is just that the defendant should be deprived of a limitation defence. As Lord Millett observed in the case of Cave, paragraph 8, if the defendant is not sued earlier, he has only himself to blame. So I think that sets out the view of the Supreme Court succinctly, that paragraph. Now, as I've stated, Section 140A of the Consumer Credit Act was not actually in force when Canada Square initially made the decision not to disclose the commission to Mrs. Potter. But Canada Square continued to withhold that information from Mrs. Potter, even when Section 140A was brought into force and came into force in 2008. And that was even though the agreement between Mrs. Potter and Canada Square continued after that point up until 2010. Now, Mrs. Potter did not find out about the existence of the commission until 2018, and that was shortly before she issued her claim. So after considering concealment and deliberately, and the Supreme Court very helpfully restated the test under Section 32(1)(b), and it's very simple. What is required is 1, a fact relevant to the claimant's right of action, 2, the concealment of that fact from her by the defendant, either by a positive act of concealment or by a withholding of the relevant information, and 3, an intention on the part of the defendant to conceal the fact or facts in question. So we've got a 3-step process there. The test is very, very simple. Now, in Canada Square itself, applying that decision to the facts of that case, number 1 was the existence and amount of Canada Square's commission on the PPI policy were facts which were relevant to Mrs. Potter's right of action under Section 140A, because she could not plead her case without knowing those facts. Secondly, Canada Square concealed the existence and amount of the commission from Mrs. Potter by withholding the information. They chose to withhold the information. And thirdly, Canada Square knowingly and therefore deliberately decided not to inform Mrs. Potter of the existence and amount of commission. And of course, this meant that Mrs. Potter's claim was not time barred. She could rely on Section 32(1)(b) to postpone the commencement of the 6-year limitation period. Now, Canada Square and Potter is, of course, a significant decision. It offers substantial and a welcome clarification of the meaning of Section 32 of the Limitation Act, in particular Section 32(1)(b), as I've just discussed. It, of course, represents the most authoritative judgment on the provision. Now, the decision is very claimant-friendly, especially in PPI and secret commission cases. So that's something to bear in mind if you ever come up to face one of these claims and you're acting on behalf of the defendant. Now, application-wise, not only are we focusing on simple PPI cases or even unfair relationship claims, this can be used and relied on in secret commission claims, whether that be in a PPI claim or, say, for example, an energy claim, energy broker claim. It can be relied on in civil fraud cases because, of course, we're dealing with fraud, deliberate concealment and mistake. That takes me on to the next bullet point, mistake claims. It can be used in fraudulent misrepresentation cases. And of course, it can be used in contractual claims with an element of concealment not amounting to fraud. So it is more wide-ranging than one would think. And it's always important to bear that in mind when you come across a case where you think it may or may not be relevant. But it's always worth having a look to see if you can rely on it. Now, just finally, when looking at Section 32(1)(b), key cases citing of Canada Square and Potter, it's of course a very new authority. There aren't lots of key cases citing it yet. However, I have mentioned here the case of Premio Fund in official liquidation against the Bank of Bermuda, Cayman. This was a Privy Council case starting in 2023. Now, this case involved an investor who had suffered an immediate and real loss each time that it had made an investment into a particular scheme, which was capable of assessment in money terms and was recoverable from its custodian as a result of its breaches of duty. Now, it was a strict liability claim against the custodian, and the court held that it was not time barred because the investor could rely on the Cayman Limitation Act to postpone commencement of the limitation period due to deliberate concealment by the custodian's agents. Now, the Privy Council relied on the decision in Canada Square and Potter to find that the adjectives deliberate and reckless had different meanings, and that recklessness was not sufficient for the Cayman Limitation Act, which is in materially the same form as the Limitation Act 1980, of course, applicable in England and Wales. I won't go any further into that because that actually touches upon Section 32(2), and it may be that Doug will be touching upon it in his part of this webinar. Now, the other case that I've referenced here is the case of expert tooling and automation against NG Power. This is a recent High Court case. This involved a business energy commission claim where the customer had known that its energy broker would be paid a commission by the energy supplier for brokering the electricity supply contracts. Now, the scope of the broker's fiduciary obligations to the customer had not included advising on the amount of the commission. Now, it was held that the customer was not vulnerable or unsophisticated, as is often pleaded in these cases, and that the commission was the customary rate of reward, so it wasn't particularly high. It hadn't gone over that tipping point again that I referenced previously in the Supreme Court case of Plevin. Now, having regard to the requirements in Section 32(1)(b) of the Limitation Act, the court held that there was no evidence of an intention by the broker to conceal the relevant facts. Now, the court noted in this case that the facts were very different to that of Canada Square, as in Canada Square, Mrs. Potter was unaware that commission was being paid at all. Now, of course, the difference here is fundamental. The customer knew from the start that there had been a non-disclosure of the amount of the commission, yet chose to do nothing about it. So Section 32(1)(b) didn't come to the aid assistance of that claimant, and the claimant was found to be time-barred. So just bringing that all together, if you are ever looking at a secret commission claim, whether it be in the PPI context, energy sector, any other sector, ask yourself right at the outset, are we simply dealing with the deliberate concealment of the amount of the commission, or are we dealing with the deliberate concealment of the existence and the amount of the commission? Because it will make a big difference when you're pleading the case and, of course, fighting the case at trial. Canada Square and Potter deals with the deliberate concealment of the existence and the amount, and expert tooling and automation and energy power deals with the alleged deliberate concealment of the amount of the commission. And of course, the decisions were very different in relation to Section 32(1)(b). So that concludes my section of this webinar. I'm hoping, yes, about halfway through, 20 minutes in. I'm now going to hand over to my colleague, Doug Cochran, who's going to deal with Section 32(2) of the Limitation Act.
As Chelsea said, I come in at this point to take up the second half of the story in Canada Square and Potter, and that is Section 32(2). And what I hope to do in my section of webinar is to answer three questions. Firstly, to answer the question, what is the problem that Canada Square is addressing under Section 32(2). And I've considered a number of different ways of setting it out. The way in which I've decided to set matters out is to look at the way in which the argument pursuant to Section 32(2) develops throughout the various appellate stages, and where it takes us in terms of the law. And as Chelsea said in her own portion of the talk, the implications for Canada Square and Potter go far beyond PPI. Obviously, this was a test case, whereas Lord Reed pointed out in his oral summary, there will be thousands of PPI cases that hinged upon it. I know from my own practice, I had at least two cases where I had to give my clients advice to say, I think this is where we're at with the law, but the Supreme Court's taking a long time coming down with Canada Square and Potter, so I don't know. And it may be the law changes as matters develop. Just to recap and highlight the portion of law that I'm focusing on, Section 32(2), we're looking at a deliberate commission of a breach of duty in circumstances where it's unlikely to be discovered for some time. And there's an interaction between Section 32(1)(b) and Section 32(2). As was stated by the Court of the First Instance of Appeal, essentially the way Section 32(2) works is as a deeming provision. It says that you look to cases where there's a deliberate commission of a breach of duty in the circumstances set out, and you deem it as though there's been a deliberate concealment by the defendant. And the question is, can this analysis apply to the facts of Canada Square and Potter? And also, how does it interact with the general Section 32(1)(b) duty that Chelsea has already set out and the facility it gives for the extension of limitation? Chelsea's already given you a summary of the facts. I just want to concentrate for my portion on a couple of important dates. One of the things that makes this case unusual is that the legal and regulatory ground is shifting all the time. So Mrs. Potter takes out her loan in 2006. Now, the Consumer Credit Act unfairness provisions are instantiated in April 2007. They have retrospective effect from April 2008. What makes Mrs. Potter perhaps an unusual and sympathetic case is that she's a very diligent debtor who pays back the whole of her loan early, in fact, in March 2010. But, of course, 6 years expires from that date. She doesn't learn about the commission until 2008, at which point she initiates proceedings. And if you have that timeline roughly in mind, one of the intervening factors which very much throws a wrench into the works is the Pleven decision, which, contrary to the prevailing orthodoxy of the time, said that even though there was no legal duty to disclose commissions, even very high commissions, or even any breach of the rules, nevertheless the unfairness provisions under the Consumer Credit Act were very widely drafted, and they were very widely drafted deliberately. And so Lord Sumption's decision, coming out in 2014, is that actually unfairness can arise even where there hasn't been a breach of duty on the part of the bank or the lending authority. And that, of course, was contrary to the earlier decision of Harrison and Blackhorse, and has set 1 million small claims running. But again, a point I will reference here in terms of chronology that is relevant as we go on is that this decision in Pleven only comes out in 2014, and it follows the discharge of the whole loan agreement in 2010. So one might argue, and indeed it was contended, that by the time that the law was clarified sufficiently in 2014 to say that there has to be this disclosure of the extent of the commission, actually it's all done and dusted anyway. So we've addressed the first of the two questions that's before the court in Section 32. Mine, of course, is the latter. Do we have an unfair? Is there a breach of duty, a deliberate breach of duty, in the creation of this unfair relationship? That is to say, the very high commission, in this case, near 95%. And at first instance, the answer was yes. And it's interesting that in Recorder Rosen QC's case, he takes the point of knowledge from July 2006, that is the inception of policy. He's later criticised for that, and in fact, the relevant date is shifted forward, the instantiation of the Consumer Credit Act unfairness provisions a year later in 2007. But nevertheless, the basic analysis he puts forward sets up the two main issues running under Section 32.2. Firstly, do we have a duty, do we have a deliberate breach of duty, and is that breach deliberate? That matter then comes to appeal before Mr. Justice J, and there's two grounds of appeal advanced. And again, we see the two issues that are going to dominate this analysis, one of which is going to be whether or not there is a relevant duty, and the other of which is the relevant knowledge test. And don't be too surprised if this appears to interact with and sound a lot like what Chelsea's just told you about Section 32.1b. The same distinction between recklessness and deliberateness that's relevant to the analysis of Section 32.1b is equally relevant here under Section 32.2. So what about the first ground in terms of the involvement in a deliberate breach of duty? Well, on appeal, there's a great reliance placed, and reliance is placed all the way up the chain to the Supreme Court in the case of Giles and Rind. Now, that's a case on Section 423 of the Insolvency Act. But what's relevant for our purposes is that Lady Justice Arden considers, although it seems as though most of her remarks are obiter dicta, considers whether or not the breach of duty has to give rise to the cause of action. And as I said up before in my setup under Pleven, one of the unusual features of this case is that the unfairness exists, but the unfairness isn't tethered to an existing legal duty to disclose. But actually, what Giles and Rind sets up, and what's taken on by Canada Square and Potter, is that the duty is merely the obverse of the cause of action. So a cause of action is created by the unfair relationship, and the breach of duty is just the other side of the coin of that. It doesn't need to be a freestanding legal duty that is breached. That legal duty exists by dint of the fact that a cause of action is created under the unfairness provisions. And that wide definition is accepted by dint of it being involved in a breach of duty. What are the second ground? And it's this second ground that's going to become more relevant as we trace matters through to the Court of Appeal. What is the mental element that is required here? Remember, we're looking for a deliberate breach of duty. And what Mr. Justice Jay says is, well, in April 2007, implementation of the unfairness provisions, we can take it that the appellant, that is Canada Square, knew that it was under a duty to act fairly and decided that the commission wouldn't be disclosed. Now, it acted deliberately in doing that. It made a decision. And as a result, we can say that there's been a deliberate breach of duty. And it's going to be this question of deliberateness in the breach of duty that the Supreme Court has to weigh in on. And the matter comes before the Court of Appeal, and Lady Justice Rose essentially, on the first question of duty, gives a thumbs up to Mr. Justice Jay in terms of his analysis. She also cites the case of Giles and Rind, and says it doesn't matter that we have this discrepancy in Pleven between the existence of a legal duty and the unfairness. What we're concerned with in the limitation provisions is whether is duty in a different sense. Is there an involvement in a breach of duty? And yes, Lady Justice Rose says, indeed there is. But what about the mental element? And here the analysis is very interesting, Lady Justice Rose puts forward. She says it's enough if Canada Square realised there was a risk that their failure to disclose the fact and extent of their commission resulted in their relationship with Mrs. Potter being unfair. In other words, a recklessness standard. And how do we establish recklessness? One of the features of this case, which is taken into account at many levels of Canada Square's appellate history, is the fact that Canada Square does not bring substantive evidence about its state of mind at first instance. So Lady Justice Rose is content to say we can infer that they were playing fast and loose. They knew, once the unfairness provisions were in, that there was a risk of unfairness, and the surrounding facts are such that they must have known. But what are those surrounding facts? What Lady Justice Rose does is she looks at pre-2010, that is to say when the loan is discharged, regulatory framework, and how the FSA, the Competition Commission, as it then was, are all sounding, as she puts it, warning signs about the unfairness associated with PPI commissions. So in other words, she says it's enough that during this period, after the instantiation of the unfairness rules, but before the relationship is discharged, the Canada Square must have been sitting there thinking to itself, there's got to be some risk that we've fallen foul of the rules. There's got to be some risk that we're sailing too close to the wind. We'll take that risk anyway. It then comes before the Supreme Court. And what's interesting is that before the Supreme Court, the issue's narrow. And in fact, the only relevant point as to Section 32.2 is in relation to the question of whether or not recklessness is sufficient to ground the deliberate commission of a breach of a duty. The existence of that breach of duty, the existence of a duty, and the breach of it, therefore, is not before the Supreme Court as a point of appeal. And what the Supreme Court does is to pick up on some old case law, which is given very short shrift at the Court of Appeal. Obviously, a number of cases cited. The one I want to focus on, which really frames their analysis, is the question of Cavan, Robinson, Jarvis, and Rolfe. That's a very simply stated factual case in which what happens is some solicitors are commissioned to secure mooring rates for their client. They screw up. Negligently, they fail to secure the rights properly. Of course, they don't know that they've made this mistake, but as barristers and indeed solicitors will be told, if you do make a mistake, if you do breach your duty, do commit an act of negligence, you need to disclose that as soon as it comes before you. Now, the reason Lady Justice Rose gave this case short shrift, and Lord Reid criticises her in the Supreme Court for dealing with the case in that sentence, is that it's not really a case that's aimed at the question of recklessness. It's aimed at the lesser standard of negligence. What Cavan Robinson says in the House of Lords is the speeches there say that obviously negligence, even negligent breach of duty, isn't good enough. But the speeches go further, especially in Lord Scott's and Lord Millet's speeches, to say, actually, there has to be a deliberate breach of duty or an intention to provoke a deliberate breach of duty in order to get over the line. They don't specifically address the question of negligence. They say of recklessness. They say negligence won't do, and what will do is a proper deliberate breach of duty. So Lord Reid, in summary, takes the case for and says, actually, no, recklessness, as it's been sent out by the Court of Appeal, is not going to be good enough to qualify you under Section 32.2. And there's a number of different strands to his analysis that he goes through. I've picked out three primary strands. The first is just simply the history of the case law. He disagrees with the Court of Appeal that we can give short shrift to cases like Cave on the basis they were focused on negligence. In his view, the proper analysis is that they affirm that what's required is something a bit more deliberate. He secondly emphasizes the ordinary meaning of terms like deliberate and reckless and the distinguishment that ordinary people put before him. He starts with the dictionary in his assessment of those different definitions. But what's more, he goes through a whole series of laws, legal provisions, in which deliberate and reckless are set out and distinguished. But I think the most interesting thread to his analysis is the policy considerations which come in at the end. And he goes back to Cave, and one of the things that Cave says is, look, if you allow negligence to qualify for an extension under Section 32.2, professional people will have no peace. They can commit a negligent breach of duty, and if it's deemed that they are now deliberately committing a breach of duty in circumstances where it's unlikely to be found out, etc., they can't benefit from the peace that limitation is meant to bring. Lord Reid extends that analysis and says the same factors, the same policy considerations that apply to negligence also apply to recklessness. Because exposing yourself to a risk and exposing yourself to a risk of a claim being made against you is part and parcel of what being a professional person is about. And he worries that lawyers and doctors, etc., will say, well, yeah, I knew when I did this, took this action, there might be some risk I would be sued over it. But he says these are exactly the sorts of people that limitation provisions are designed to protect. And the reason we have Section 32.2 is to say there are special cases where there's been some deliberate conduct on the part of the would-be defendant that we want to say, no, that actually extends the term of limitation. If we were to say that recklessness qualified, then the mere exposure to a risk, which every professional person does, dare we say banks who engage in lending policies do, if that was enough, then it would take the teeth out of the limitation regime altogether. The conclusion, therefore, though it's perhaps less relevant to Mrs. Potter, given the finding on Section 32.1b, is that the failure to disclose the commission, even though it is a breach of duty, doesn't therefore get over the second hurdle, the second limb, that it is deliberate. Mere recklessness won't be enough. And as we've said before, that has policy implications which radiate well beyond the world of PPI. That brings us to the end of the talk. If you'd like to drop any questions either in the Q&A function or in the feedback forms that will be sent out to you, we will respond to those in at least one of two ways. We'll either address those questions directly to you by email, or when we update the slide deck, we will put in those Q&A questions in writing along with your answers so that everyone can see the benefit thereof. So we won't do an oral Q&A here, but if you'd like to put your questions in the chat or send them through the feedback forms, I would be very happy to get back to you. Thanks very much.